The Supreme Court didn't just decide a case. It quietly rewired the entire engine that determines how gun laws live or die in America. And that rewire already changed 5 major battlegrounds that affect where you carry, what you own, what you build, what you sell, and what you hand down to your family. Most gun owners have no idea any of it happened. They are still running on the old map. They are still trusting rules that have already shifted underneath their feet. And that gap between what they think is legal and what actually is legal right now is exactly where people get into serious life-altering trouble. Here is what I am going to do today. I am going to walk you through all 5 of those changes the way they actually affect your daily life. Not with law school jargon, not with stuff that only makes sense if you pass the bar. I am going to break it down clearly, the way a serious gun owner needs to hear it, with real scenarios that put you in the situation so you understand what the stakes actually look like from the ground level. Because this is not academic. These changes are happening right now in courts right now, and they are producing outcomes that affect real people who thought they were doing everything right. Before we get into it, I need to ask you something important. Are you subscribed? Because this kind of information does not stay accurate forever. Gun law moves fast, court orders drop, injunctions flip. What is legal this month could be restricted by next season. Hit that subscribe button right now so you get the update the moment it matters. Because I promise you, you do not want to find out you missed it standing in a police parking lot. Now let's talk about the engine running underneath all 5 of these changes, because without understanding this part, the rest of it will not fully land. Most people think gun law is straightforward. Congress passes a law, the president signs it, done, or the Supreme Court rules on something, done. But what the Supreme Court really controls is the test that every judge in the country has to use when deciding whether a gun law is even allowed to exist. And for years, courts used a balancing approach. A judge would weigh the gun restriction against the government's stated reason: public safety, crime reduction, whatever the justification was. The judge had wide room to say, yes, that seems reasonable, and uphold the law. Gun owners kept losing, not always because the Constitution was against them, but because the test was stacked against them. Then came New York State Rifle and Pistol Association versus Bruin. That single decision changed the test entirely. Now, when a gun law gets challenged, the government cannot just say, this law feels reasonable or that it makes people safer. They have to prove that the law fits within America's historical tradition of firearm regulation. That means looking back at founding-era laws, colonial period regulations, and legal patterns from the 1800s to find genuine historical matches. If the government cannot find that historical match, the law is presumptively unconstitutional. That is not a minor procedural tweak. That is the entire game changing. And because it changed the game, it opened up 5 completely different areas of gun law that are now actively in flux. Here's the first one, and it is one that a lot of gun owners think they already understand. They do not. Red flag laws, extreme risk protection orders. Whatever your state calls them, you know the basic concept. A family member, a law enforcement officer, sometimes even a teacher or a coworker can go to a court and say this person is a danger to themselves or others. A judge issues an order, you lose your guns, and in many states, this happens before you even get a hearing, before you even know what is coming. After Bruin, a wave of legal challenges hit these laws hard, and a lot of gun owners celebrated. They said red flag laws are finished, the history test will kill them. There were no red flag laws in 1791. That is where people are getting fooled and where the celebration is dangerously premature. Courts are not asking whether the exact same law existed in the founding era. They are asking whether there is a historical tradition of temporarily disarming people found to be dangerous. And the answer to that question is more complicated than the victory headlines suggest. Courts have found historical examples. Surety laws from the 1800s, going armed laws, laws that allowed communities to disarm individuals deemed a public threat. None of these are identical to a modern red flag law, but they are close enough that some courts are using them to keep those laws alive under Bruin. Here's the shift that actually matters to you. The legal fight has moved away from whether red flag laws can exist at all, and it has moved on to how they have to work before they can take your property. The pressure is now on due process. How much notice are you entitled to? Can you appear before a judge before your guns are removed? How long can the order last without a full hearing? What standard of proof does the petitioner have to meet? These are not resolved questions. They are live questions being argued in courts right now. Picture this, honestly. You had a bad week. You said something frustrated to a family member. Maybe you were venting. Maybe it was taken completely out of context. Maybe there is a messy divorce happening and things are tense on every side. Someone files a petition. A judge signs an order at 8 in the morning before you even wake up. By the afternoon, law enforcement is at your door. In that moment, how well do you actually know your state's specific red flag law? Do you know how many days you have before a follow-up hearing? Do you know whether you have the right to an attorney at that hearing? Do you know exactly how to challenge the order and get your property back through the correct legal process? Most gun owners cannot answer any of those questions. They assume someone else is handling it at the legislative level. They assume the courts will sort it out. But you are the one living under the current version of the law in your state today, while the legal battle works itself out over the next several years. Know it. Do not wait to find out the hard way. The second change is one that will surprise people who think it has nothing to do with them because they are not running a gun business. Pay attention to this one. Congress passed the Bipartisan Safer Communities Act, and tucked inside that law was a significant change to the definition of who is considered engaged in the business of selling firearms. That definition used to have meaningful room for people who sold guns from their personal collection on an occasional basis. The new version tightened it significantly, and here is the legal twist. The Supreme Court's recent decisions have made courts more skeptical of agencies stretching statutory language beyond what Congress actually wrote. But when Congress writes the tighter definition directly into the statute itself, the agency does not need to stretch anything. The tighter rule is now the law. Here is what most people are getting wrong. They think this only affects people running table setups at gun shows or operating out of a storefront. That is not how the rule reads. The question is whether you are dealing in firearms with the principal objective of livelihood or profit. But the line between a hobbyist who sells a few guns a year and someone who legally qualifies as engaged in the business is not painted clearly on the ground. It never was, but it is even blurrier now. Here is the scenario you need to sit with. You buy firearms because you enjoy it. Sometimes you sell one when you find something better or when you need extra cash. Over the course of a year, you sell 5 or 6 firearms through private sales. You are not running a business in your mind. You are a collector managing a collection. But depending on the pattern, the frequency, the profit margins, and the circumstances, that activity can now attract serious federal scrutiny under the new standard. No federal firearms license, no background check facilitation on those sales, potentially a federal issue sitting quietly in your recent transaction history. The practical takeaway is not that you need to stop buying and selling legally. It is that you need to understand where the legal line actually sits in the current environment, not where you assumed it was 2 years ago. If you regularly sell firearms, even casually, speak with an attorney who actually understands current federal firearms law. The definition changed. Your assumption about what counts as casual may no longer match what the statute says. The third change is one the Supreme Court has not fully resolved, and I told you at the beginning that sometimes the most dangerous situation is the one where nothing seems to have happened yet. Federal law has long prohibited federally licensed dealers from selling handguns to anyone under 21. Various states have their own age restrictions layered on top of that. After Bruin, these laws got challenged directly. The argument is straightforward. The Second Amendment protects the right to keep and bear arms. 18-year-olds are legal adults. They can vote. They can serve in the military. They can sign contracts. They can purchase long guns. So why is there a categorical ban on handgun purchases from licensed dealers for people who are legally adults in every other context? Courts have split hard on this question. Some have found a historical tradition of restricting arms for younger adults and used that to uphold the restrictions. Others have looked at the historical record and found it too thin to justify a categorical ban on handgun purchases for legal adults. The Supreme Court has not stepped in with a definitive ruling. That silence is not permission. It is a pause before a decision that is still coming. And in the meantime, you are living in genuine legal uncertainty that depends enormously on which federal circuit you happen to be in. Here's the scenario that actually catches people. A 19-year-old in a state with its own handgun purchase age restriction goes to a private sale. The federal dealer restriction is not the issue there, but the state restriction applies. That state law is being challenged in court. There is an injunction pausing enforcement. Then the injunction gets stayed. Then it gets lifted again. The legal status flips back and forth while the appeal works through the system over months or even years. A 19-year-old who made a purchase legally under an injunction could find themselves holding property that became restricted again after the injunction dissolved. That is not hypothetical. That is exactly how injunctions work in active litigation. The law changes while the case is still moving, and you are caught in the middle without ever intending to do anything wrong. Watch this one carefully. The quiet from the Supreme Court on this issue is not a green light. It is a clock ticking toward a decision. The fourth change involves something most gun owners consider settled, permanent, and untouchable. And that assumption is now dangerous. Suppressors have been regulated under the National Firearms Act since 1934. Federal tax, registration process, background checks, a wait time that can stretch to a year or more. For decades, gun owners accepted this as a permanent part of reality. Then Bruen changed the historical test, and legal challenges started targeting NFA regulations from a completely different angle. The argument being developed in active litigation is this: the government cannot point to a genuine historical tradition of regulating sound suppression devices, because such devices did not exist in a form that would have been regulated during the founding era. You cannot have a historical tradition of regulating something that had not been invented yet in any meaningful sense. The Supreme Court has not ruled on this directly, but lower courts are beginning to receive these challenges, and the way those courts apply Bruen's historical tradition test to NFA regulations will shape whether suppressors remain locked inside a 1934-era regulatory framework, or whether that framework starts developing real constitutional cracks. Here is the most important thing most people are getting wrong on this one. They assume that because the NFA has existed for 90 years, it is automatically constitutional. Bruen specifically and explicitly warned against that kind of reasoning. The length of time a law has been on the books does not settle its constitutionality under the new test. Long-standing is not the same as historically grounded. Those are two completely different things, and the court was crystal clear about it. Here is a scenario you probably have not thought through. You paid the tax, you waited 8 months, you completed every step of the process correctly, you have a legal suppressor on a registered firearm. A court in your circuit then issues a ruling that NFA registration requirements for suppressors violate the Second Amendment under Bruen. Suddenly, you are in legal territory where the old rules you followed and the new ruling are pointing in completely different directions. What is your compliance posture? Who do you call? What do you do with the item you legally own, while the federal government figures out how to respond to the ruling and potentially appeals it through the system? Most gun owners have never thought through that scenario because they assumed NFA was settled law forever. It is not settled anymore. Bruen moved the floor. Keep your eye on suppressor litigation. It is moving faster than the mainstream headlines are showing you. The fifth change is the one that will make some people uncomfortable, but the legal reality is already here whether we talk about it or not, so let's talk about it. After Bruen, a significant wave of challenges hit the federal laws that prohibit certain categories of people from possessing firearms at all. The most prominent early example was United States versus Rahimi in 2024, which involved the restriction on people under domestic violence restraining orders. The Supreme Court upheld that restriction, but do not look only at the headline. Look at what the court actually said. They clarified that they are not looking for a historical twin of every modern law. They are not requiring the government to produce a law from 1791 that looks exactly like today's restriction. They are looking for a historical principle. And the principle they pointed to in Rahimi was this: governments have historically had the authority to disarm people who represent a credible, demonstrated threat of violence. That clarification gave lower courts a roadmap, and it also opened a door that defendants across the country are now walking through. The argument being made is that the founding era did not have a categorical, permanent, lifetime ban on firearm possession as a civil disability for people who had committed crimes. People were punished, sometimes severely and permanently in other ways, but complete, irreversible disarmament as a lifelong condition attached to a criminal conviction is harder to find in early American history than most people expect. Here is what this does and does not mean, and you need to hear both sides clearly. This does not mean the felon in possession law is going away. Do not take that from what I am saying. What it means is that courts are being forced to examine the category with far more precision than they have in decades. And in doing that, they are starting to ask questions that have not been seriously examined in a long time. What kind of felony? How long ago was it? Was it violent or nonviolent? Was the person's rights restored at the state level? What does the specific state's restoration process look like? Courts are splitting on these questions right now. Here's the scenario that matters for a lot of families watching this, including families who think this issue has absolutely nothing to do with them. You have a family member, maybe a brother, maybe a grown son. He has a felony conviction from years ago. It was a nonviolent offense. He served his time. He has been completely clean since. He has built a life, has a job, has a family, owns a home, and under the law, as it has been applied for decades, he is still a prohibited person for life with no path forward in many states. Courts in multiple circuits are now actively asking whether that lifetime categorical ban survives Bruen's historical tradition test for someone with that specific profile. Some are saying yes, it survives. Some are saying the historical record is insufficient to support a lifetime ban for nonviolent offenses. That is a live legal split happening right now. If that situation is relevant to someone you care about, and they are currently getting legal advice about their options, they need counsel who is actively tracking these specific cases as they develop, not advice based on the legal landscape from 3 or 5 years ago. litigation moves. The arguments available today are not the same arguments that existed before Bruin. Now, here's what you actually do with all of this, because I am not going to leave you with a pile of information and no direction. This is your practical framework going forward. First, stop trusting outdated summaries and gun shop conversations as your legal foundation. Every time you see a headline about a court ruling, ask yourself 3 questions before you move on. Is this a Second Amendment case under Bruin's historical test? Is this a federal statutory definition case about what words in an old law actually mean? Or is this an agency power case about whether the ATF or another agency overstepped what Congress authorized them to do? Those 3 types of cases produce very different outcomes and affect your life in very different practical ways. A lot of people celebrated or panicked over rulings they fundamentally misunderstood because they did not know which category the case even fell into. Second, understand that Bruin is an engine, not a destination. The history and tradition test is still producing results. Courts are still fighting over what counts as a sufficient historical analogy. New rulings are coming in areas you probably have not been tracking. Red flag procedures, age restrictions, NFA regulations, prohibited person categories, the definition of what constitutes a firearm under 1968-era statutory language. None of these are fully resolved. The cases working through the circuit courts right now will shape the landscape you are living under for the next decade. Third, understand that where you live is now a legal variable that determines your daily risk level as a gun owner. Federal law sets a floor, state law builds above it, and states have responded to Bruin in radically different directions. Some expanded gun rights significantly, some layered new restrictions specifically designed to work around what Bruin prohibited them from doing directly, some created legal ambiguity that has not been resolved by any court yet. The sensitive places battle is a perfect example of this. When states could not stop people from getting carry permits after Bruin, they pivoted to making the entire map of daily life a sensitive zone. Parks, public transportation, restaurants that serve alcohol even if you are not drinking, medical facilities, banks. And in some states, they tried to flip the default rule on private property entirely, making it a criminal offense to carry onto any property open to the public unless the owner has affirmatively posted a sign permitting it. That inverted framework is the opposite of how carry law has traditionally worked in America, and it is being litigated right now. Fourth, treat legal travel as a separate skill set that requires active preparation. Every time you cross a state line with a firearm, a suppressor, a magazine over a certain capacity, or certain accessories, you are entering a jurisdiction with a potentially different and actively shifting rule set. The Federal Firearm Owners Protection Act from 1986 is supposed to protect you while traveling through restrictive states as long as your firearms are locked, unloaded, and you are genuinely passing through. But banned state prosecutors and law enforcement have become increasingly aggressive about what passing through actually means. If you stop overnight in certain jurisdictions, some courts and prosecutors take the position that your FOPA protection dissolves the moment you check into a hotel, because you have now possessed that firearm in that state, rather than merely transiting through it. That is not a hypothetical worst case. It is an active enforcement posture in states like New Jersey, New York, and Illinois. A flat tire on the New Jersey Turnpike with a standard capacity magazine in your range bag is not a hypothetical. It is a scenario that has destroyed real people's lives who thought federal law had them covered. Fifth and finally, build an actual system for staying current, not just a vague intention to keep up, a reliable source you check on a regular schedule, a calendar reminder before any out-of-state travel, a contact who can give you current, jurisdiction-specific information before you move, because the single most dangerous assumption any gun owner can make right now is that nothing has changed since the last time they thought about it. These laws are not static. They are moving simultaneously at the federal level, the circuit court level, and the state legislative level, all at the same time, all pointing in different directions depending on your geography. Running on old information in this environment is not just ignorance, it is risk you are carrying without knowing you are carrying it. Here is where we land. The Supreme Court did not just decide one case about carry permits in New York. It changed the methodology that every federal court in the country now has to use when evaluating whether a gun law can stand. That methodological change is producing ripple effects across red flag law procedures, the definition of who qualifies as a casual seller versus a dealer, handgun age restrictions for legal adults, the constitutional foundation of National Firearms Act regulations, the definition of what a firearm actually is under laws written in 1934 and 1968, and the scope of who can be permanently disarmed under the prohibited persons framework. Some of those ripple effects look like wins for gun rights, some look like losses or new restrictions, and some look like nothing happened at all. That last category is the most dangerous of all. It is the silence that keeps you from realizing the ground shifted while you were standing still. The Supreme Court declining to hear a case is not a resolution. It is a gap in the map that you now have to navigate without guidance, and you have to navigate it knowing that your rights in one state do not exist 1 mile across the border. If you own NFA items, if you buy and sell firearms, if you travel across state lines with any of your gear, or if you have a family member navigating a complicated legal situation involving past convictions, you cannot afford to operate on old information. The cost of being wrong in this environment is not a fine. It is a felony. It is mandatory minimum time. It is the permanent loss of rights you thought you already had secured. Subscribe right now and turn on notifications, because the next video is going specifically into the 5 questions every single carry permit holder needs to be able to answer cold before they walk out the door in the morning. If you cannot answer all 5 without hesitation, you are carrying with real legal exposure you have not accounted for. I will break each one down the same way we did today, practically, clearly, and with the scenarios that show you exactly what the risk looks like from street level. This is not about fear. It has never been about fear. It is about staying on the right side of a line that keeps moving, and the only way to do that is to know exactly where the line is today.